Hello, Divorce and Beyond family. I've got some exciting news because we have teamed up with Headspace to guide you toward better mental health. With Headspace's meditation, mindfulness tools, and mental health support, you're set for a journey to a happier, healthier you. And there's more because if you sign up through our exclusive link, you'll enjoy 2 weeks of Headspace membership for free. So don't miss out on this opportunity to embrace your well-being. You can check out the show notes for the link or just go to divorcebeyond.com/headspace-Susan. And you'll be able to start your path to peace and joy today. This is just one more way that we can support you on your journey to a better beyond.
Coming up on today's episode of the Divorce and Beyond podcast.
Most cases don't need to be litigated and shouldn't be litigated. They need to be settled. But there are cases that you have no choice because you're dealing with a personality disorder where someone's incapable of settling. You're dealing with an amount of money and a legal issue where you have to decide what to do with that money, and it's too much to just negotiate away or settle away. You're dealing with custody or domestic violence. You need to get to the bottom of it, understand why things have gotten the way they are and what the best path forward is. And sometimes you need a judge to do that.
Hello, and welcome to the Divorce and Beyond podcast. I'm Susan Guthrie, your host. As a top divorce attorney and family law mediator for 30 years, I know what you need to know to get through your divorce and, most importantly, how to move beyond it to thrive and transition to your new future. My experts and I are here to give you the insider view into the process, so listen in for the wisdom and expert information you need on your journey through divorce and beyond. Hello and welcome to today's podcast. I'm Susan Guthrie, your host, and listeners, it's still January, still divorce month. And so this whole month, we're going to be tackling the really critical topics of divorce. This week, it's when divorce gets messy, why litigation is sometimes the only answer. And, we've talked many times about the fact that most divorce cases settle out of court, but sometimes cases demand litigation, and that can be because of high conflict personalities, contentious custody battles, or complex financial disputes. When litigation becomes unavoidable, having the right attorney makes all the difference. And that is why I am thrilled to have as my guest today, attorney Marc Garelick. Marc is a highly sought-after family law litigator who has extensive experience in those high-conflict custody disputes, spousal support battles, and complex financial cases. He's the managing attorney for his California Orange County office, and he specializes in stepping into the toughest cases and bringing strategy, expertise, and a results-driven approach to the courtroom. In this episode, Marc is going to share why some cases do require litigation, how to prepare for the courtroom, and the key skills that set great litigators apart. So if your case feels stuck, or if you're wondering right now if litigation is your next step or your first step, Marc's insights will give you clarity and direction. So don't miss this chance to learn from one of the best. Let's get started with today's episode. So Marc, thank you so much. I know, we are here in the first full week of January taping this episode. It's divorce month. This is the busiest time of year for divorce attorneys. And this year, I think it's true. Isn't that what you're finding?
We call it divorce month because everyone files for divorce after the holidays. And so what we've been seeing is already, even last week, which was New Year's week, people are calling for new cases and new filings of divorce because they've had enough with the holidays.
Yeah.
So it is just a marathon of new clients, new cases, new issues that we all get to deal with all at once.
Yeah. Well, and that's what I'm trying to bring some new episodes to my listeners and touching on topics that I think people need to know about if they're in sort of the January state of mind. But I do know how busy it is for you. So I very much appreciate your coming on and making the time for this, because you and I are going to talk about something that, frankly, in 310 episodes, I have not talked about. And in fact, I've talked in many of those 300 plus episodes about the opposite. I am always talking about the fact that most cases don't go to litigation, don't actually end up on trial. But the reality is there are certain cases where there's no other way to get it done, or it's just the best way to get it done. And that is your sweet spot.
You're right. Most cases don't need to be litigated and shouldn't be litigated. They need to be settled. But there are cases that you have no choice. And you either have no choice because you're dealing with a personality disorder where someone's incapable of settling. You're dealing with a amount of money and a legal issue that might have not the greatest answer to, where you have to decide what to do with that money. And it's too much to just negotiate away or settle away. And then I think you have like the heart issues where you're dealing with custody or domestic violence. It's not really a split the baby kind of solution. You need to get to the bottom of it, understand why things have gotten the way they are and what the best path forward is. And sometimes you need a judge to do that.
Yeah, these are those cases. And that's what we're talking about today, is the ones where it does take the person in the black robe to bring it to a conclusion. And I do want to emphasize for my listeners that I think it's about 95% of cases do go to judgment with an agreement. And so, I'm going to say this as a longtime family law practitioner. The vast majority of practitioners who hold themselves out as litigators are really people who prepare for trial, but all along the way really are negotiating a settlement, and the vast majority of their cases settle. And you're a little different, because when I said it's your sweet spot to litigate, it's actually where your wheelhouse lies. Taking those cases, that other 5%, bringing them into the courtroom in the right way, right? With the proper support, with the proper preparation, so that the clients and the family can get the best outcome.
Yeah, and so it's not necessarily the first option. So you don't want to necessarily hire the big gun and the litigator right off the bat to litigate your case, because you should be doing what you just said, which is trying to settle it. So many times I come in after a settlement conference or maybe after an initial hearing where everyone realizes that the case needs more resources, it needs the right evidence, it needs the right discovery and depositions and whatever needs to get done to get the case ready for a trial, a hearing, something that will actually move the case forward. So I see a lot of cases that are just stuck. So if your listener has been trying to settle their case for 2 or 3 years and they're getting nowhere, and they're at a point where they don't know what to do, the answer is probably some form of litigation.
Right. And I love you just said if they've been litigating or they've been moving their case forward for 2 to 3 years. You're in California, as I mentioned in the intro. California, practice there myself, is about the only state in the country that I know where 2 to 3 years isn't actually all that long in California. That happens more often than not, but it is an indicator that maybe something needs to change. Something needs to be handled differently, right?
It's generally a pattern, right? So you have a settlement and then a settlement and maybe a little bit of discovery. Enough time goes by where nothing happens, and then it turns into settlement and a little bit of discovery, and you keep on going down this wheel. And in order to get a case moving forward anywhere, sometimes you need consequences for a party, for the other side, for lawyers, for something to happen to move the case forward and actually get results and get done. Because the ultimate goal is to be done. It's not to be stuck in our court systems forever. And it's not necessarily to be stuck there so that you get a fair deal. It's to be done. You have a lot of litigants who just get stuck on an issue, on a point. I see a lot of personality disorder issues where someone might be a little high on the narcissism scale, or they might have anxiety issues of not committing to settlement. And you see this going on and on and on forever. And when I say 2 or 3 years, I generally look at that as a very, very small point in time to be in litigation. I just finished a trial where we were at our 13th year.
Oh my God.
Think about it. The kids were 2 when the case started and are now 15 and 16.
They're almost aged out of being even an issue in the divorce at this point.
Right. You just need to get to trial. And there are lots of ways to get to trial. There are productive ways. There are expensive ways. There are heart-wrenching, difficult ways that you have to go through a custody evaluation or you have to go through other forms of discovery. But sometimes you just have to do it. Otherwise, you're going to get caught in that cycle.
Well, and so you bring up several good points there. And I think, as we're talking about this in divorce month in January, many of the people who are listening may be in the early days of the process. And so one of the things that I sort of wanted to touch on that you mentioned is often you are not the first attorney that handles their case, right? So for people who are sitting there right now thinking, I'm getting divorced, I need to go out there, my ex is an ass, or they cheated on me, I want to nail them to the wall, or whatever those things are. You and I both know, even with that level of emotion, many of those cases settle. And it's just that there's high emotion in the moment. So what you're really talking about is you're brought in, I'm going to put you in a category of sort of being a specialist for those cases where the normal path just isn't getting it done.
Yeah, think of me as almost like the pinch hitter.
Yeah.
You have to come in and it's not, you don't want to necessarily have to spend hundreds of thousands of dollars on family law litigation. That's crazy when you think about it. And you only want to do that when you have no choice and you have to protect what you have to protect. And it has to make sense. So it can't just be, I'm going to come in there and I'm going to, issue all of this discovery and be this train and just knock them out of the ballpark. That's a waste of time and money for everyone. Your first idea should be, can I settle this? Can I go to a settlement conference? What documents does everyone need to get this resolved? What really is the issue and what is the worst case and best case scenario in court? When you go through all of that and you realize that, my best case scenario is way over here and his is way over there, and there's really nothing in between, that's when you need to start thinking, well, maybe I need a judge to make orders to move this forward. A good example of that is a custody move away case. Someone's moving away someplace far. Either the children are going to live with that person on, a more regular basis, or the other person. They can't just have a 50-50 custody schedule when you live, 200 miles apart. That's an issue that you're going to need some kind of court order if it's seemingly both of you want the same thing.
Right. That's actually a great example. You also mentioned some other instances, one being where we're dealing with high conflict or we have personality disorders in the mix. I've got to tell you, I was just looking to see out of my episodes what my top 10 of all time are. And 9 of the 10 deal with narcissism, high conflict divorce, or, my ex is unreasonable, that type of thing. So those are the popular cases. And it's not, face it, we both know if there's a personality disorder in the mix, those people end up getting divorced. It's very difficult to be in a relationship there. So how often does that come into play for the cases that you're brought in on?
I don't want to say every case, but it's certainly very close to it. I was reading a study and it was something in the high 90 percentile of someone with a DSM diagnosable narcissism that it's like 98% they will go through a divorce in their life. And you have to understand that someone who is suffering from a personality disorder like that generally is incapable of introspection. So they're not capable of looking inside themselves and going, wait a minute, maybe that is reasonable what they're asking. I should probably settle this case. It's usually the opposite. They're thinking that, so I'm going to go the other direction. And in a case like that, it should be straightforward. Okay, they're way out there. They're not going to settle. Let's move forward with some form of a court order so that there's a consequence.
Right. Consequence and conclusion. I loved that you brought that up earlier, because one of the things that we know for people going through divorce is the period of time between making the decision to get divorced and finalizing the divorce is one of the worst hells. I always call it Dante's, 10th rung of hell that he forgot to mention in the Inferno, because that limbo that you live in where you don't want to be married anymore, but you're not actually divorced, and you're trying to work out, what you can do, how things are going to settle out, what's going to happen. That's a really tough place to live. And that's another reason to reach out for help, when you hit that point where it's just not going to settle.
It's a danger zone, I think. You're living in the same house together. You are adversarial now at this point. So you're in small quarters. There could be a letter that goes from one lawyer to the other that is very settlement minded and peaceful, but it's not taken that way. And there you go. You have to share a bathroom, or you have to, have a meal, or go to a kid's sports activity together. They become very dangerous. They're high risk environments for domestic violence. You could be accused of domestic violence very easily. And it also can turn into a real incident of domestic violence very easily. So it's very important that you get those issues resolved quickly, especially the initial custody support, move out of the family residence. And again, when you know that it's insurmountable, or when there's a real personality disorder, that's when you have to start thinking, hey, I need a court order now, and I need it quick, and I need to figure out how to get one.
Right. And that's, the only way you're going to get an order is in a courtroom, right? That's the only person who has any power. I've told it to clients for years, because they come to their attorney and they're like, you need to do this for me. And you're like, hey, the, law degree did not come with any special powers. All I get to do is go be an advocate in court. The only person with power is the judge, and they're the only ones who can issue those orders.
That's right. But I will say with that a judge is only as good as the information that they receive.
Very good point.
Incredibly important that you are able to present the evidence in an organized, succinct fashion to the court, and you need to make sure they hear the words that they're looking for. So if you're going in and getting and seeking a domestic violence restraining order, you need to use the words that the judge is looking for to see if there is domestic violence. You can't just go in and kind of spill your guts out and, vomit on a piece of paper and hope that the judge gets it, because the judge is not going to get it. Judges have strange ideas of custody. There are state policies of one size fits all, 50-50 just works. And that's rarely the case when you have high conflict matters. And generally, when you try and throw that into it and make it work, it doesn't, and it gets worse, and you end up in more litigation.
Let's take a quick break here for a new sponsor promo, but first, I want to give you a sneak peek at what's coming up next in this episode. In the second half, Marc and I are going to dive into one of the most important aspects of litigation, and that is how to find the right attorney and build a winning team. We'll also talk about what it takes to make a litigator truly stand out, and we're going to share some practical tips for navigating high conflict cases. This second half is packed with insights you don't want to miss, so stay tuned.
So your attorney should be able to tell you with some degree of certainty the best case scenario of you going into that court and hitting it out of the ballpark, and then the worst case scenario if the judge is grumpy, gets out of the bed wrong, and just doesn't like the fact that you're wearing a blue tie and not a red tie that day, so that your client has the right expectations going into court.
Now, let's take a little minute to talk about something special. If you follow me on Instagram, you all know how much I love my evil eye pendant. I love I have my bracelet. I have the pendant that goes around my neck. I wear evil eyes all the time. And so many of you have reached out asking where I got them. I'm thrilled to share with you all, drum roll please, that my favorite jewelry source, Yumi Yu Jewelry, is now a sponsor of Divorce and Beyond. For me, Yumi Yu jewelry is more than just jewelry. The symbols are symbols of strength, individuality, and empowerment. And they handcraft each piece with love and care. And so they are designed to help women stand out and embrace our unique personalities. So whether it's an evil eye, like I have chosen for protection, a hamsa for faith, or any other meaningful symbol, their pieces offer beauty and inspiration even during these tough times like divorce. So here's the best part. YumiU is giving my listeners an exclusive discount if you use the code BEYOND, that's BEYOND, all caps, at checkout. You'll get 20% off your order. 20%. So if you're looking for a meaningful piece to keep you inspired or to protect you during this difficult time, visit divorcebeyond.com/YumiU. That's YUMIYU. And treat yourself or treat someone you love to something special. You deserve it. Now, let's get back to the second half of the show. I mean, that litigation cycle is sort of an ongoing conflict cycle. The more litigation you have, the more conflict you have, and it keeps going. And I think it's really important, something that you just mentioned there, because litigation as a practice for attorneys, some people are really good at it, others aren't. And it's just, we all come out, we all go to the same sort of law schools, we all take the same sort of classes. Some people don't even have advocacy courses. That's an elective in most cases. Having spent 30 plus years in courtrooms, one of the things that I can say is some people are good at this and have the skill set, and some people aren't, but either they don't know that or they don't tell the clients that. And so let's talk a little bit about the skill set, because you've sort of alluded to it here, but let's get to the nitty-gritty of it. What is the skill set that a really good litigator brings to the courtroom on behalf of their client?
It's, I think, a couple things. One of the most important is the ability to pivot. Judge is going to make comments. Things are going to happen in court that aren't part of your what-if scenario. And you need to have an attorney who's able to pivot, understand what's just happened, and be able to advise you of the best path to go down at that point. I'm trying to give a good example of that, but let's say that a judge, you're in a custody dispute, one side's pushing for a custody evaluation, one side doesn't think it's necessary, and then the court brings up minors counsel, which is kind of a third party, represent the kids, and gives the court the idea of what's in their best interest. Minors counsel can be devastating to a case. It could be wonderful to a case. You never know. They're an unpredictable third party. So you need to be able to pivot and look at the facts of the case and understand them, and then be able to present that to the court in a way that helps your client, whether good or bad, and let them know what's going to happen. And then the other thing I think is really important with a litigator is to understand the court and what the judge likes and doesn't like, as well as what the likely best case and worst case scenarios are with that judge. So your attorney should be able to tell you with some degree of certainty the best case scenario of you going into that court and hitting it out of the ballpark, and then the worst case scenario if the judge is grumpy, gets out of the bed wrong, and just doesn't like the fact that you're wearing a blue tie and not a red tie that day, so that your client has the right expectations going into court. I see a lot of people who are represented by attorneys. They go in there and they're just completely blindsided because they had no idea what was going to happen that day or what the possibilities are going to happen in that day. And then something out of left field happens, right? The minors counsel question comes up and they had no idea that that was even a possibility. Just those expectations are extremely important. And then the last thing is really just kind of the basic skill set of, knowing your Discovery Act, knowing your Code of Civil Procedure, knowing how to object, knowing when to object, and how, to not piss off your judge by objecting too much.
Yes.
A lot of young attorneys go in there and objection, and you can't do that. You have to get the evidence out somehow, even if the other side doesn't know how to ask a question.
Yeah, I've seen a lot of eye rolls with judges when we've seen that paradigm in a courtroom. And I think, you raised some points there that are really imperative for clients to know if they are facing a courtroom situation. And part of that is who is representing you absolutely matters. And in a variety of different ways, having that sophistication level on the part of your counsel, right? That they know both I always talk about what we learn in law school, and it's not really what people maybe think. What we learn, we can't learn all the laws in the world, in the state we practice in, right? There's too many laws to memorize. But what we learn is how to look at a law, know a law, and look at the facts of a case and how to smush the two of them together so that we can present our client's case and the facts of our client's case within the construct of that law, right? That's what law school is. It's how to think like a lawyer. Some people do that better than others. And it's the ones who can do that quickly on their feet, pivot like you were saying, right? When something changes in that courtroom, we don't know with a crystal ball what's going to happen in that courtroom. You're right. The judge may not have gotten their smoothie in that morning, or may have had a fight with their spouse, or whatever it might have been, not slept well and not respond well the way that you think. So having experienced counsel who know the court that they're dealing with, the judges that they're dealing with, the laws that they're dealing with, but also who have almost that extra level of just, I called it sophistication, but just that level of knowing how to maneuver within that courtroom. It's really the magic element that not that many attorneys have.
Part of it too is just having a general strategy before you walk into that courtroom, down to, how you want your client to dress, how your attorney is dressed, what type of evidence you are going to pick and actually present to the court that you think is the most relevant evidence, and why you think that evidence is relevant, because that becomes important too. A lot of times people just want to throw everything against the board and have a 20-day trial by just asking, is this your bank statement? Is this, your money? Is this your W-2 statement? I can tell you judges don't care. They can read those documents themselves. They really want to get to understand and make credibility determinations of your client, if they're being truthful. If they're not, if they really do have a personality disorder, it's going to come out when I put somebody on the stand and start asking them questions that they're not going to be able to answer because they think so highly of themselves. You need to have that strategy. You need to be prepared. You need to have your questions drafted. You need to have your exhibits, your exhibit lists, your witnesses ready and prepped. Know kind of the system that the court uses. A lot of courts are now going into electronic evidence now. And so we have to understand, what the knowledge of that judges is of that evidence, and then how we actually present that evidence.
Right. And, you're raising such good points, because there's it's a very different paradigm than working to settle a case, right? When you're working to settle a case and you're negotiating a settlement, you're trying to put things on the table that have a little incentive for the other party to accept what you're offering, right? They have a reason why this would work for them, and or to give you what it is that you're asking for. Negotiation is a delicate dance of its own. But litigation is it's like saying you're salsa-ing on one side and you're breakdancing on the other, right? They're completely different dances, and the preparation is completely different. How you go into the plan is completely different. And you said the one word, we actually talked about this a lot in last week's episode, Divorce Day 1, which was strategy. But what we talked about in last week's episode was sort of having a strategy of how you were going to negotiate. Right. And I want to distinguish for what we're talking about here. You're talking about a litigation strategy, very different.
That's right. I always like to make a train track analysis. So it's two trains going down two different paths. And maybe they're parallel, maybe they cross at some points, but you have one train that's going down the litigation path and then one train that's going down the settlement path. Just because you're going down the litigation path doesn't necessarily mean that the settlement train has to stop, though it might slow down considerably because you have to prepare for that hearing or that trial. And there are points where they cross, where you may have worked up the case and are ready for trial. And with some certainty, again, what your best case and worst case scenario is at trial. And the other side may be just as prepared, which would be a good thing, or not as prepared and seeing that you're prepared. And that can sometimes lead to, 11th hour settlement because everyone knows what the judge is going to order at that point.
That's a part of the persuasion, right? And that can be part of what compels someone to settle. So one of the things I mentioned that you're in California and you work mainly in California, although I think you are also called in on cases outside of that jurisdiction. Is that correct?
Yeah, we've done Nevada, Oregon, Washington, Illinois, and New York.
Hey.
Yeah, generally, they are very big, bulky litigation cases that have some issues related to California. We call it quasi-community property, where you need to bring in California attorneys to help educate, in Illinois courts what community property looks like, and why, so that they can make the right ruling. Our practice is mainly focused in California, and throughout the state, both Northern and Southern California.
So for those who are listening and who are looking for a litigator in California, clearly you're available. My advice, reach out to Marc. But if they are not in California, if they're in another state, what would you tell someone who's listening about looking for the, sophisticated litigator that we're talking about?
So when you meet with them, and always, I don't know if you tell your listeners this, but you should be meeting with more than one.
Always. I say 3 at least.
At least 3. Family law is a personality thing. You have to, jive with their personality. You have to be able to relate to them. You have to have a tremendous amount of trust in your lawyers, especially when you are litigating. You're looking, I think, when you're meeting with them, if they're able to come up with some kind of strategy within that first meeting. It shouldn't be rocket science. They should know exactly what the strategy should look like, or at least the beginning stages of it. They need to be able to kind of understand your court and your case. If you're going in there and saying, hey, I'm dealing with a high conflict case, and the other side is narcissism, and they were like, well, that doesn't really matter that he has narcissism, probably not a litigator, because that's just what we deal with in family law as litigators. We know that those are the issues that we have to deal with. I would also look with their kind of network of consultants and experts. Many times you're going to meet with somebody and it's litigation, and you're going to want to have somebody who is a forensic accountant expert, who is a custody consultant expert, or a custody evaluator, or a drug testing expert. All of those become very important people in litigation, and that attorney should know 3 or 4 names off the top of their head right when you meet with them, that those are people you need to retain as well.
I want to emphasize that. I think that that's a really key component, is that a really good litigator isn't operating solo. Really good litigators know the team to pull together that is the right team to get your case over the finish line in that courtroom, right? The team that's going to help present it. So even in that consulting phase where you're talking to a potential litigator, asking them about the resources that they have, both maybe in their firm, but also externally with their experts, is really a critical question.
I like firms that generally have a team approach. So it shouldn't just be the partner at the highest billing rate doing all of the work in your case. That's, again, sign of someone who's probably not a litigator. They should have associates or junior partners or whatever paralegals that might be, who are billing you at a lower rate for more of the discovery work and maybe some of the drafting work that needs to be done. And then that person that's the high billable rate should be kind of the lead, directing everybody where to go and how to do it. And then the person who's going to be there in court, taking depositions and at the settlement conference, whatever it might be.
Yeah. And that's a really important point for everyone, because we hear litigation, people hear litigation, and they immediately think dollar signs. And they're not wrong. Litigation is expensive. It's no more expensive, I've always said to people, than a case that needs to be litigated that's just running through the negotiation process but never comes to an end, right? Because you just sort of keep pouring money down a drain that's never filled if you can't settle it in negotiation. But it's a very good note to people, is that ask the attorney when you're interviewing them, because that's what it is. A consultation, folks, is an interview. You're deciding who you, the client, want to hire. And that's why it shouldn't be just one person. It should be at least 3 attorneys. But ask them about the team that they work with. Ask them about how they help you manage the costs of the cases. Really good attorneys take that into consideration. You just heard Marc talking about it.
And then I'd also say, look who your spouse or ex-spouse is retaining. If they're going to retain a sophisticated firm, and then you're going to retain, your friend's friend who went to law school, who does some family law on the side, just imagine what that's going to look like and feel like, because they're going to get outmatched by resources. So it's important to know who is on the other side. Is the other side hiring a bunch of experts? If you have no experts on your side and the other side just hired 3 experts, the court's going to listen to those experts and you're not going to have anybody to rebut it. It's important to know what's happening on that other side too.
Another good point. You're full of golden nuggets for my listeners, which is wonderful because that is something to raise in your consultation. If you know who's representing your spouse, be sure that you let the attorney that you're interviewing know about that and get some input from them. Do they know this person? It's, family law. There may be thousands of us around the country, but it's a small world when you're in a certain particular geographical area in practice. Everybody gets to know each other. I remember the days where a summons and complaint would have come across my desk and I'd see a certain name on there as the attorney who signed the summons and be like, well, this one's going to be a bigger battle than most, right? Because as you said, everybody has a different style and a different approach, but it's important to know that. And it's important to know what your potential attorney knows about that person because it becomes a part of what you talked about in strategy, right?
Right. And how you're going to approach them, how you're going to deal with them. Is it that bulldog fighter lawyer on the other side who's just very difficult? Or is that person known for settling hard cases or resolving hard cases? We all have reputations within the industry as well. If you went to another family law attorney in Orange County or LA County, they're going to have heard my name. They're going to have some experience with our firm, and they're going to tell you, hey, they're litigators. Is this case a litigation case?
I think all of those points as you're considering, because again, remember, Marc is the attorney that comes in most of the time well down the road, meaning you've been working with an attorney. They've been trying to settle the case most likely for you. Things have moved along, but it's not going to settle, right? That's where we're at. This is a trial is an inevitable moment, and it's time to not change teams, but bring in new leadership, right? Bring in your new coach, and by coach, I mean the person who's in charge, as you were saying here. One last thing I want to touch on is the case where you have domestic violence. Because very often, if there are people out there who are listening right now, very often with several kinds of domestic violence, they know right now that is something that is in their case. And I'm just wondering your thoughts on a case involving DV, intimate partner violence, domestic abuse. Do you feel that a litigation approach is probably more appropriate from the beginning with those cases?
I'll give you the lawyer answer is it depends.
Yeah.
But, certainly if it's significant domestic violence, there's a threat, then you need to litigate that case. You need protection. You need orders, right? You need a consequence so that it can't continue. I think they get more complicated when there are kids involved, especially young kids. It's very difficult to resolve those cases because in California, if there is a finding of domestic violence, then it creates a presumption that the other party's custodial time should be limited. So it creates another wrinkle. It's not something that is very easily or should be negotiated, right? We're looking at the best interest of kids. And when there is domestic violence, the best interest is not to be put in an environment that's violent. And that includes all kinds. It's not just physical. It's coercive control. It's emotional. It's all of the things that can create that environment that puts somebody in fear.
So if you're in that category, right, you may be wanting to reach out for a litigation attorney earlier rather than later.
Right. Or even right off the bat. I mean, if it's enough where it's substantial and there's you're going to know pretty quickly that you need to fight and protect yourself. If you are able to kind of realize that, and it's hard. I mean, people go through cycles of domestic violence and, they get the worst and they end up in a honeymoon phase and they come out of it. But if you have that realization that you need to be away from this person, then you need to be away from that person.
Well, and you said the most important word, right, which is safety. It's really one of those things where if there's domestic violence or domestic abuse and you and or your children or your pets, because we know they get included in this as well, but are unsafe, a litigator from day one might be the right path. So So much that we've covered here. I know we could continue talking forever, but I'm going to direct people, if they're in California or have an issue that you might be able to help them with, how can they reach out to you, get in touch with you? What's the best way?
Sure. So we have our webpage, which is molfamlaw.com. It's Meyer, Olson, Lowy, and Myers. Or they can give us a call, 949-397-3977.
Okay. And I will put all of your contact information in the show notes, as I always do, everyone. So much here, and really so wonderful to be able to get your nuanced take on this. I very much appreciate your time and all of the golden nuggets for my listeners. Thank you so much, Marc.
Thank you for having me.
Thank you for joining me today on the Divorce and Beyond podcast. I hope you found some information and inspiration to help you on this journey. Please join me every Monday at 6 a.m. Eastern Standard Time for a new episode. And if you like the show, please take the time to subscribe and leave me a 5-star review on iTunes. You can also find more information on the website at divorceandbeyondpod.com, where you'll find links to the YouTube channel, transcripts of the episodes, and other bonus content. So I'll see you next week to help you move through your divorce and beyond.